Hi, I'm Huntsville criminal defense attorney Andrew Siegel of Siegel & Siegel. Today's topic is what you need to know if you're accused of shoplifting in Alabama. First thing that you need to know is what are the elements, that is, what is the definition of this crime. Shoplifting is simply a type of theft crime under Alabama law. It's not a separate crime, it's a type of theft. The way that shoplifting is committed under law is that somebody takes property of another person with the intent, or in this case a store usually, but takes property of another with the intent to permanently deprive the owner of that property. That's the legal definition. Let's get a little bit finer on the details. Taking of the property has to be with intent. So to use the example I like to use, if somebody has maybe a roll of paper towels or some dog food or something in the bottom of their buggy, and they walk past the checkout line after paying for other things and they've forgotten about it, they wouldn't be guilty of shoplifting if they had no intent. That doesn't mean, unfortunately, that they might not be charged, but it would be up to a jury or a court to decide whether or not they were in fact guilty of the offense. They wouldn't be guilty as far as their mental intent, and hopefully they would be found not guilty. But the jury or the judge will decide what the facts are from the evidence in the case. Now, the other aspect of a theft case is taking. I have here my eyeglasses. Let's say I went to a vision center, and I said, well, I like those eyeglasses, but I didn't want to pay for them. So I take them and I move them from here to here so it's easier for me to grab them on the way out. Even if I've just moved them a very short distance, if I've done it with the intent to steal, I am guilty of the crime. It doesn't matter if a person didn't get out the door. People seem to think that, well, gee, I never left the store, so I can't be guilty of shoplifting. That is absolutely not true. As soon as something is picked up with the intent to steal it, that person would be guilty of shoplifting because it's taking with the intent to steal. And that completes the crime. Now, whether it can be proved in a courtroom is a different issue, but that would complete the crime. I want to talk now about the different degrees of shoplifting, which are really just different degrees of theft, as I've said. The most serious is what's called a Class B felony under Alabama law. Alabama law says that a Class B felony can carry a punishment of up to 20 years in the state penitentiary. For somebody to be guilty of the Class B version of shoplifting, they would have to take property that has a value of over $2,500. So I guess it would be something like somebody stealing a diamond or maybe a very expensive piece of equipment or something from a store. The second type is a Class C felony, and that means somebody has taken property that has a value of between $2,500 high end and $500. That is what's called a Class C felony under Alabama law. That carries a maximum sentence of 10 years in the state penitentiary. The most common type of shoplifting case that we see is also called theft third. Theft third means that somebody has stolen property that has a value of not greater than $500. That is the most common. It's a little bit different on the sentencing because if that case is charged in a municipality, that is in a municipal court, the maximum sentence is 180 days in jail. But if the case is charged in the state, meaning in a district or a circuit court, then the case has a maximum sentence of a year. I'm not going to go into the details as to why there's a difference. Just take my word for it, there's a difference on the range of punishment. The next area I want to talk about is what can we lawyers do to help somebody who has been accused of this crime? The first thing you need to know is that even if somebody is dead on guilty, that doesn't mean that the case will automatically result in a conviction. There's a variety of reasons for this, and again, I don't want to make this video forever in length, but one of the most common things that lawyers will do is try to negotiate, particularly in the case of somebody who's a first offender. We'll try to negotiate with the prosecution to see if it's possible, if the prosecution will agree to allow the person to attend some form of counseling, where if they successfully complete the counseling, they can avoid a conviction. That's a pretty common thing for us lawyers to try to negotiate. Certainly should talk to your lawyer about that. If it's a case where it's appropriate for a trial, if the person didn't do it, and if the evidence is such that it probably wouldn't support a conviction, then it might be a choice to go to trial. Most people don't like to have trials. You will have to decide based on the circumstances of your case and your conversations with your attorney as to what is the best course of action for you. Obviously, if you're charged with any crime, you need to talk to an attorney as quickly as you possibly can. We're happy to help you here at Siegel & Siegel. If you want to, just give us a call. Our number is 256-533-4529, 256-533-4529. Sorry, I screwed that up a little bit. But at any rate, if you call us, your first consultation is free. I don't believe in charging people. We don't believe in charging people for talking to a lawyer to decide whether or not they want to hire a lawyer. I think that's a little crazy. There are lawyers who do that. if you talk to us, and if you talk to any lawyer, that consultation should be absolutely confidential. That means I can't tell anyone, I can't tell your wife or your husband or your mother or your sister, nosy relatives or anyone. That conversation that you have with your lawyer stays. It's like the Vegas thing. Anything that happens in Vegas stays in Vegas. Anything that happens within the walls of your lawyer's office stays there. Again, if you want our help, give us a call. I hope this video has been helpful to you, and thank you for watching.